Buenos días y bienvenidos al tercer webinar que
Good morning. Welcome to our third webinar that we launched from the International Residence Unit in the Provincial Council of Alicante with regards to Brexit. In this third webinar, we are going to deal with legal aspects of Brexit. Both in the first webinar and second webinar, we had Bavaria Association and the consulate, so it has been a success with more than 150 registered people and also the representations that we made afterwards. Today, we have the help of Ignacio Pellicer and Pedro Heredia. They are two experts in international law and they want to collaborate with us. So we have asked them to explain about their experience, their vast experience, and to explain to all the residents in the province of Alicante who are worried about the situation that they are living today with the Brexit. We have to hear them because they are both experts, and I'm sure they are going to sort out many of the legal questions that you may have about Brexit and the situation that you're living now. So I invite you to ask as many questions as you wish and to do as many comments as you wish so that they can answer all of them. And also in the Provincial Council website, which is ciudadanosextranjeros.es and brexitdiputaciondealicante.com, you can also have access to the answers of the questions that you've made. So I give the floor now to Pedro and Ignacio so that they can give us all the necessary information that we all wish to have. And I want to thank all the people that have registered today, more than 100 people. And we want to give all this information to the 141 municipalities that we have in Alicante so that everyone is aware of the situation that we're living and they have an answer or a reply to the questions they may have. We've got more than 80,000 UK nationals in the province of Alicante, and I am sure there are many more that wish to come here. So on behalf of the administration, we want to give you as much help as possible and to provide you with the necessary tools so that you can answer all the questions that you may have at each moment. So thanks, Pedro and Ignacio, for your collaboration and for your help and support to this webinar. So I give you the floor. Thank you very much.
Hola, buenos días. Good morning. Hola, buenos días. Okay, well, let's start with the webinar. Thank you very much, Juan de Dios Navarro. Thank you very much, Esther Ponzoda, and obviously the Diputación de Alicante and the Department of Relaciones Internacionales. I personally think that you are making a really good job in order to inform, which are basic information for legal aspects, for situations that the foreigners can have in this territory, in Costa Blanca, which is a really good effort that you are doing, and I'm really pleased. Specifically, right now, with the situation about the British citizens that are residents in Spain or are looking for being resident in Spain in the future. And today, what we are going to speak about is about the legal aspects, or which is the situation that came from and now how has been changed, and which is the situation of which are our recommendations on what to do in different steps. I'm going to share a PowerPoint where, in order to conduct and guide, there are three pillars where I'm going to speak. The first one will be for taxes as Ignacio Pellicer and myself, we understand is a pillar of what the situation has changed for the British. Before the Brexit were non-European Union citizens, and now were European Union citizens, and now they are non-European Union citizens. So So there are some changes on the residency taxes or non-resident whenever you have some interest. For example, you own a property in Spain. Also will be the immigration regarding what happened with the TIE before the Brexit now, how can be applied. What about the non-lucrative visa? What about the golden visa, which is, we are receiving many questions about that. And well, obviously the health system, if something is changed or not. And there are some other issues that we may speak if obviously if you have some questions regarding wills, property, investment, litigation. I mean, all these questions we may be able, if we have time, we may be able to speak about it. Hello, Ignacio. Buenos días. Good morning. We cannot hear you. We cannot hear you right now.
Okay, sorry. Good morning. Thank you very much, Juan de Dios. Thank you very much, Esther and Diputación, for thinking of us on sharing with you today a little bit on the expertise on all the legal aspects on Brexit, which we have been receiving a lot of questions. And we've been trying to inform the expat community wide enough. So thank you for your support, especially to all this community, which they really need support in this time. Thank you, Pedro.
Okay, so well, let's start with taxes. I know, Ignacio, we agree that it is important that you make a tax planning whenever you want to come to Spain. Obviously, whenever you are in Spain, obviously to know which is your tax scenario, which is your tax situation. And obviously for with the Brexit and the legal aspects for the British that are residents or non-residents has changed slightly. Okay, first of all, let's make a difference about if you are resident in Spain or non-resident in Spain, or if you are tax resident in Spain, or if you are non-tax resident in Spain. So let's start with the non-resident tax. Is whenever someone has a property in Spain, owns a property and have a property as a holiday home, or have a property as non-resident and rent it out in order to get some income. Also, if you have some income from work. Okay, well, when someone has a property as a non-resident, before that, I mean, obviously now you also have to pay and declare non-resident tax, which is IRNR, which is basically comes from a number from the catastral value, and then is taxed into is obtained a number from 1.2 or 2%, and then is taxed on 19%. That was before the Brexit, and now for the non-residents is 24%. It's a tax which is very small, but it's something that needs to be done correctly. Another thing that has changed because of the Brexit for non-residents is about the income that you obtain from property. Before that, you were able to include costs on rental, say IBI, council tax, and some of the maintenance costs that you may have before. And then whatever amount it was taxed on 19%. Right now, this has changed, I would say, a lot. And it's taxed on 24% the gross amount. You cannot deduct costs on rental. And obviously income from work, any kind of work that you do as a non-resident, and you have to declare it as non-resident tax, will be taxed on 24. This probably, I would say, that is the worst situation about the property, which is, we understand that there are many British that have property in Spain and are getting some income, and now will have to be taxed on 24%. The good thing is that interests, dividends, capital gains will be taxed on 19%. For example, I am not resident, I own a property, I want to sell it, and on the date of completion will be retained, will be deducted 3%, and then you have to, in case that you have a capital gain, you will have to pay the rest of 16%, so it will be 19%, it will not be 24%. There are no changes on this, which is good. So if you have a property and you get some income, you pay 24%, but remain the same in case that you sell a property, will be 19% on the capital gains. Obviously, the interest, dividends, or well, capital gains on, for example, on shares before was exempt and now is not. Okay. What if I am resident in Spain, but I want to sell a property in Spain and I want to go back to my country? I want to go back to UK. If that before the Brexit, there was exemption on that in order to reinvest the main home that you had in Spain as you were resident in Spain, even though that a year that you sell the property, you are non-resident tax. I know this is a little bit complex, but is whenever you sell a property, if you are non-resident in Spain on tax purposes, and if you reinvest it in the UK before the Brexit, you were able to get an exception on non-resident tax. Now no longer can be applied this exemption, even though, and we have received many questions regarding, well, what if I am 65 years old? In that case, if it's non-resident, it is considered, if that year you are non-resident, will not be longer exemption. Okay, Ignacio, if you want to add anything regarding all this, please interrupt me and enter that. It is important to differentiate, Ignacio, about when someone is tax resident and when someone is non-tax resident. Can you give us a little bit of explanation of this, please?
Okay, a very good point, Pedro. Thank you for your question here, because a lot of people are in Spain already and they need to do things properly according to law. And there is a lot of people as well that there are in the UK or abroad and they need to do tax planning. We highly recommend people to do tax planning, and we are doing so much now after Brexit. A lot of people need to know that if you spend more than 183 days in Spain, you will have to do your worldwide tax declaration in Spain, and that will have an impact which you could do simulation and know the answers. So first, a piece of advice, Pedro, I will give to the international citizens here is please seek independent legal and fiscal advice and work out your scenario so there is no surprises. There is a way, if you decide to come to Costa Blanca here, you could even put yourself into a position being non-resident, which it is, you will only need to be paying your taxes on non-resident tax and the property that you own in Spain. Or you could put yourself into a picture of being fiscal resident in Spain. Therefore, all these laws that Pedro is saying will put you into position as a resident in Spain and paying tax here. Very important, if you do this move, to disconnect yourself from the home country where you are and connect yourself here, or just the other way around. And I think now we'll talk a little bit on the implications on the TIE, which is the first step for you to get the residency permit that Pedro will talk to you. But basically, Pedro, what I would like to share with the audience here, tax planning is good. We're still now on the time to do the income tax return from April to June. Right. They're still on time to do it. I suggest them to do this exercise and there will be no surprise. Over to you, Pedro.
Okay, thank you, Ignacio. Okay, well, let's move on. We have received an explanation of when you are tax resident or non-tax resident. What are the implications for non-residents? British non-residents have some interest or own a property in Spain, but what about the residents in Spain? I mean, there are some changes, but the main concern, I would say, is that selling a property or the main resident will be exempt if you are over 65 years old. That remains the same, which is good. But the exemption for reinvestment is no longer, as you can see in the slide, is no longer applied. I mean, that's a pity because, I mean, at the end, this rule, this article from this specific act, it comes into the European Union countries. And obviously, United Kingdom is not anymore a European Union country, and that exception is no longer applied, cannot be applied. So this is why it's important, as Ignacio said, in order to check previously all this tax situation, make a tax planning, whether situation in order to sell, whether, I mean, if we are over 65 years old, if you're just going to sell it, what will be the capital gains or what will be the tax implications, or if you are tax resident or not in the future whenever you sell the property. Okay, this is one of the pillars. I think there's, in order to see which are the slightly changed, there are some other changes regarding taxes. For example, someone who is non-resident and can, before that, has the option to to be subject to a tax residency. But I think that is very technical, and obviously we're going to focus on what implications may happen to those who are individuals, residents or non-residents in Spain, and particularly in this area, in Costa Blanca. Okay, one of the pillars also I said before, it is immigration. Ignacio, obviously we've been in, I would say in the last 2 years, on the past year and the latest months, regarding the TIE has been showed about in order to change residency into a new card, a card that identifies you. And there has been some difficulties to some people in order to apply appointments, and there has been some difficulties in order to obtain residency in the latest months. Now the situations for those who want to relocate, to those who want to come to Spain, and particularly to this area, will be a different issue, and not with the British citizens that were residents in the past or have some rights in order to apply residency. According to the Article 50 of TUE, Tratado de Unión Europea, and the Article 18.4 of the Withdrawal Agreement. Ignacio, could you give us a background about the TIE, what happened in the last months before the 31st of December last year, and what about implications, and what about the court cases that are starting to come?
Okay. Okay, Pedro, very good point. As I said before, when somebody just decides to come to Spain, to Costa Blanca, and they wish to start a new life here, the first thing they need to do is get the residency permit if they've been living in Spain for more than 3 months. That was in the old days, the green A4 form, it changed into the green card, and then it passed into the TIE. The TIE is Tarjeta de Identificación de Extranjeros, which is a foreign identity card, which is got your biometric and your fingerprint, which is having the TIE allows you not to hold anymore your British passports, and you're identified as a resident. You could even go to the notary, go to court, go to whatever administration with that TIE. Some of you that might be listening today might still have the green paper green card, which is still valid. There's nothing wrong with that. It's just a certificate that proves that that person, that name, along with the passport, you are a resident in Spain. But the paper is not an identification, obviously, card. Okay, so this is one of the benefits I considered. Now, the administration encouraged people to swap it and exchange it. And we've been doing that for many, many clients, and we highly recommend you to do it. Again, it's not compulsory, but will bring you a lot of benefits. Why? Because under the Article 18.4 of the Withdrawal Agreement, you make a formal petition to the administration to be recognized with all your rights and obligations according to that treaty. If you don't have the TIE, that means probably you didn't do that formality, even though it's a formality. And in some scenarios, like for example, buying a property in the area of Torrevieja, Cabo Roche, and all these areas, you will need a military permit. One of the things they will request you for that, you're a non-European country, but you need to have your TIE in order to make the application for that permit in an area where it is limited to some certain authorities. So one of the requirements in certain areas will be to get the TIE. They wouldn't allow you with a green card anymore because you need to be under the withdrawal agreement and formal application. Now, we've been doing a lot of them. There is in Heredia, as you might know, a Brexit department, which is still open, and they're being very, very fast now, very quick, because there is less queue, less people on it. As you know, you've been trying to prove here to become with a TIE, you need to be living in Spain. You can still apply and submit that TIE for those who didn't do it. If you already had the green card, you could swap it. You only need your passport, photos, and pay a police tax, okay, administration tax. That's for one of them. For the other ones who probably by any reason didn't do it in the past, obviously the things, Pedro, are getting a bit more complex. Why? Because you need to prove that you're being on the padron for 2020, obviously have for more than 3 months money in the bank, 9,000 euros, and prove that you have enough funds abroad as well. you will need to have health insurance or convenio especial or being employed by somebody here.
Exactly.
So there are a lot of conditions that now, Pedro, we are finding that a lot of rejections on TIEs for some square reasons. For example, not having your padron register in 2020. Okay, but there are solutions to that. And as you said, Pedro, there is a time to do the appeal, and you have the option to appeal before the Heredia office, or you have the option to appeal before the courts and ask the judge to put a preliminary measure asking you to live in the area, to live in Spain legally with a temporary residency. Obviously, all that brings court runners, barristers, and it takes time. Is an average on these going through the courts. It takes time. It's not as smooth as making the application through Heredia. But if you, by any reason, do not comply with the requirements of Heredia, even though I might consider it, you are entitled because you're a resident. Let's say you are living here, you've got witness here, your mayor knows you're here from a long time, but you didn't submit yourself the application through the town hall, then you will need to take the case further. Unfortunately, Pedro, as we expected in the past, we're seeing more and more situations for these British citizens that they still did not register themselves in the Heredia office. So I really encourage people either coming from abroad, which now Pedro will speak is in a different situation, like the non-lucrative visa, the golden visa, the social ties visa, work permit visa, or for you who probably the people who's listening here now, Pedro, is people who were living in Spain, who probably just paid their taxes here, but probably they didn't make the application for many reasons. I highly encourage them to apply for the TIE as soon as possible, Pedro. And I will pass over to you, Pedro, to carry on with the issues of the immigration situation.
Okay, thank you, Ignacio. And obviously, I mean, about the TIE is something we highly recommend always. Yes, you've been resident in Spain, you are resident, even though you have not applied for the TIE, or I mean, it's a matter of proof. And the certification of empadronamiento is I would say it's a really important document. It's a really important document in order to show, well, to have access to convenio especial in case that you are more than 1 year. And it's a really important document to show that it's a matter of proof, obviously, whenever we go to, in this case, to court or to prove to immigration office, but it's a really important document and needs to be issued correctly. Okay, so for those British citizens that would like to come to Spain and live in Spain, apply for residency or have some kind of visa in order to enter back and forwards into Spain, I would say there are two main applications or two main vehicles in order to conduct the application to come to Spain. One of them is the non-lucrative visa, and the other one is the golden visa. I would say that is the most questions that we are receiving from British right now. And I would say that is the two of more applications that are being made right now by British. Let's focus firstly for the non-lucrative visa. Well, this is the TIE, according to as it says, Ignacio, Article 18.4, Acuerdo. This is an example, obviously. And because of the agreement, permanent Artículo 50, Article 50 TUE. This is the example of a TIE according to the Withdrawal Agreement. Okay, for the non-lucrative visa, is a visa. It was prepared and focused for those who are retired, who come to Spain in order to retire from a third country, non-European country. That's extremely, I mean, that's important. It's an issue. It's a must that you don't have to be European Union citizen, because on the immigration office there are like two kind of queues. One queue is for European Union citizens, and some other countries like Switzerland, Norway, Iceland. And then we have the other queue is for third countries, non-European Union citizens. The non-lucrative visa comes from that, from people from China, from Russia, from the United States, and now from UK, have to apply for the visa in order to apply for residency in Spain. It's a visa that do not allows you to work. That's the main point. You come to Spain to retire, and you will be a resident in Spain, as you will be getting the residency. Important points or requirements. I don't want to extend a lot on this, but as criminal record, certification of criminal records is a must for the last 5 years. You need to show the last 5 years criminal records. There is an institution named ACRO, A-C-R-O. If you Google ACRO, you will find where to get this criminal record for the last 5 years in the UK. Obviously, all the documents that are in English will have to be, and public documents will have to be apostilled by the Hague Convention, 1961, and then will have to be translated as a sworn translator. This certification of criminal records is a public document that needs to be stamped by the Hague Apostille in the Commonwealth Office in London, and then will have to be sworn translated. Well, certification of criminal records. Then we have obviously the public or private healthcare or insurance or access to healthcare in Spain. You need to show, basically, you need to show that you have access to the public system or to the private system through an insurance, a policy insurance. To have access to the public system, obviously by the S1 or by those rights that comes from the United Kingdom. But what we recommend, obviously, in order to obtain residency, and once you are living in Spain for 1 year, maybe to change into a convenio especial. It's like a special agreement between Spain, well, between the Social Security and those who would like to enter in a special agreement or access to public system. But basically what we recommend is just to apply for insurance or a private insurance policy, which covers you for the first year. Non-lucrative visa allows you to live in Spain, to reside in Spain, not to work for 1 year. After 1 year, you are allowed to renew it for another 2 years. After 2 years, you are allowed to renew it for another 2 years, and then we go to 5 years. So it is 1 + 2 + 2 + 5. Okay, and in those years, in the first year application, well, I would say one of the most important requirements that you need to show is the financial means. So you need to show that you have enough money to live in Spain. How do you show that? I mean, it's a matter of proof: bank statements, savings that you have abroad, income from any institution or company. At the end, you need to prove or show that you have enough money to live in Spain without working. You may be, I mean, it's a question, Ignacio, that has been always showed, that what if I come to Spain with a non-lucrative visa and I work remotely from a company in the UK or in a different kind of country? Well, at this time, technically, you are not allowed to work. Obviously, there is no specific rule on that. You are not allowed to work or to enter in the system. But the most important thing on this is that you need to show that you have enough savings, enough money, that you don't depend on work in order to live in Spain. Okay? And well, obviously, you need to show also a medical certification in order to show that you have like a big illness according to the International Health Act 2005. Well, this is easy to obtain it in your home country. Obviously, we have to be, if it's a public document, again, apostille with the Hague Convention and then sworn translation. If it's a private document, just a sworn translation. Okay, as I said before, the non-lucrative visa, it comes into 1 + 2 + 2 + 5. You will be able to renew it every time. I mean, 1 year, 60 days before the second year, renew it, and so on. Forbidden to work, you will be able to, in some ways, to work remotely, but this is technically you cannot work. But in case that you have savings that you don't have to work, you don't need to work, well, I understand in some ways should be accepted. And obviously you are able to bring also your family members, suppose children non or legal age, and also parents where may depend on you on health circumstances or maybe economic circumstances. And Ignacio, again, for the non-lucrative visa, as you become resident in Spain, that attracts you for taxes, is that right?
Yeah. That's exactly, Pedro. It's very important for people to understand. On one side, you've got the immigration side, and on the other one, the taxation. Obviously, sometimes they're matched, but sometimes you could still have a permit to live in Spain, but not necessarily be fiscal resident, as you know. And this is a lot of things. For example, one of the practical scenarios is, if I apply for a non-lucrative visa, do I need to stay in Spain more than 6 months? Well, the answer is yes. Now, if you stay more than 6 months in Spain, do I need to declare my worldwide income in Spain? The answer is yes. So if you have a golden visa, let's say you bought a property that Pedro obviously will explain later on, over 500,000 euros with the requirements he will explain, then you have the possibility to come in and out with that visa, do whatever you have to do remotely, do everything, and be non-tax resident. Now, if you apply for a non-lucrative visa, you are obliged to stay for renewal more than 6 months. Let's say you want to apply for a non-lucrative visa, but you stay less than 6 months. You will have to apply for that again because you didn't comply with the immigration requirements of staying for 6 months. Okay, it will be very messy, but that's probably another possible scenario for some of those who just decide to come, but they probably are not going to reach the 6 months. Very specific situations, but the requirement for the non-lucrative visa to be renewed, obviously, is minimum 6 months in Spain, which obviously ties you in with the tax situation, as you said, Pedro. There is some people, again, that might have the TIE, which makes you resident in Spain. And for those, my probably perceptions is very, very high position of being tax resident. I don't see very much having a TIE and probably being non-tax resident, you see. But it could be some exception, it could be some cases, as long as you all have your TIE, you stay in Spain less than 6 months, and you were able to prove that that's true, because tax office could exchange the information with the immigration office and say, well, you've got your TIE, you should be doing all your tax here. Why are you not declaring your income tax return here in Spain? And then you need to do tax planning and prepare the whole thing according to dual taxation treaty between the UK and Spain. Why you are a no tax code in Spain because your address is over there, which is a possibility because you stay there more than 6 months, and because according to a dual taxation treaty, UK did confirm on writing that you're a tax resident in the UK. So this is some of the scenarios, exceptions, obviously, which you could still, on one hand, the TIE, and on the other hand, you can still be non-tax resident, but you need really specific advice on that, and you need to do it properly, Pedro. So yes, over to you, Pedro, with regards to
okay, thank you, Ignacio. Latest information about the non-lucrative visa. You need to do it in your Spanish consulate, in this case in the United Kingdom, Manchester or London, and you need to do it personally. You need to submit it. You need to apply for an appointment, and the period of time really it comes from whenever you submit. Obviously, you need to get all these documents before. And those documents do not have to skip 3 months, so you have to apply for the non-lucrative visa in the following 3 months. Once you have, before 3 months, once you have obtained these documents, and the Spanish consulate have 3 months to make a resolution, positive or negative. So it takes around maybe, let's say around 1.5 months, 2 months. And then once you are informed that you have obtained a visa, the non-lucrative visa, you have 1 month to go and get it. And then it will give you 3 months in order to enter in Spain. And you will start being resident in Spain from that. So it will take around, I always say up between 3 and 5 months. So it's something that you need to take into account, okay? Then let's go to, well, to the golden visa, which is something, well, it's not similar, but it's something that is also being applied or being questioned about. What about the golden visa and the requirements? Okay, the golden visa. Well, one of the main investments that are made through the golden visa, which a golden visa is an investment program, an investment visa, is which is the minimum, is the property. If you invest in property with a minimum of 500,000 euros, then you will have the right, in case you want to apply for the golden visa. Obviously, when someone is non-European Union citizen. So 500,000 euros will allow you to enter in Spain with a visa. And maybe if you wanted to, be resident in Spain. It's a autorización de residencia por inversor, which implicates that you have a visa to entry back and forwards into Spain. And obviously, you will have access to the Schengen area with all these countries. Obviously, with this formula between the 3 months into 6 months, that's as we have also right now with those who do not have residence in Spain. Okay. Requirements for golden visas, more or less the same, except the investment. With the non-lucrative visa is not being resident in Spain, obviously not being European Union citizen, obviously not have any file against you, you have not been illegally or you are not illegal in Spain whenever you apply, criminal records, that's important, and again, sufficient money to live in Spain. It's exactly the same requirement as the non-lucrative visa, but in the golden visa, you need to make an investment, and that's important. Even though it allows you to live and work also in Spain with the golden visa, it's important that you show sufficient money to live in Spain with the same requirements. Well, for the non-lucrative visa and for the golden visa, the financial means for one person is 27,000 euros. For 2 people will be 34,000 euros totally as a minimum, okay? And you will be able to bring your family members, spouse, partner, children, legal age, economic dependent. And in this case, with the golden visa, it's slightly different. For the non-lucrative visa, it's not limited, it's a little bit more flexible with the family members and also dependents. But it's something that you can do. This is the point really I wanted to inform you. Apart from buying a property of 500,000 euros, you could buy 1 property, 2 properties, 3 properties, but the minimum investment totally needs to be done in 500,000 euros. And it doesn't matter if you invested 2 years ago, 5 years ago, or this year and also next year. Once you prove that you have invested 500,000 euros in property, in 1 property or in 10 properties, it doesn't matter, then you will be able to have a right to obtain the golden visa. For it is, as I said, it is important that you need to know that can be included those investments that has been done after 2013. When it was approved, this law, okay? And well, criminal records, as I say, or again, insurance policy, and then you have shown the investment. In this case, would be for the land registry certification. That is something easy and simple. Okay, you will be able to work and live in Spain. And important to say about this is that will be for 1 year and then 2 years and 5 years. You can do it in the Spanish consulate, or maybe you are here in Spain personally and then you apply for that also for 2 years, starting for 2 years. Renewing, you need to inform and show that you have maintained the investment. You can change the investment, you can sell a property and buy another property, you can sell the property and invest in a different investment requirement, let's say 1 million euros in deposit or different investments. You can do that, no problem, but you need to maintain the investment whenever you want to renew it. And important on this also, and it's a question, Ignacio, that many clients and applies for that. If I apply for non-lucrative visa, or if I apply for golden visa, and this is specifically for golden visa, I am tax resident in Spain. That's a question that is being made a lot.
Yeah,
I mean,
yeah, and actually
it is rejects, if you could apply for golden visa, rejects totally tax situations or not?
Right. As I said to you, and I think we've got in the chat some questions about how could I have a TAE and be non-tax resident? Obviously, that's very, very difficult. And as you are saying, Pedro, how can you get a non-lucrative visa and be non-tax resident? Obviously, one thing links the other, but one thing, it doesn't make the other thing automatically. So if you've got your TAE, obviously you could apply for the TAE. You've been living more than 3 months when you did apply, and then you will stay here. But there is some questions here, Pedro, even people giving back the residencia. We've got here Graham asking and saying that he wants to give back the residencia. Right, obviously, for those who give back the residencia, you need to bear in mind, if you've been staying more than 6 months or not more than 6 months, you'll be tax resident in Spain or not. Again, as you said, TIE, but you've got that because it's a right, you've been living here, but you've been resident in Spain, but not fiscal resident in Spain. Why? Because even though you had the permit to stay here, you spend more time abroad because a lot of people are working, Pedro, abroad and spending much more time. And therefore, there is a dual taxation treaty, which implies and it needs to be applying here, and use article number 3, which is what is the domicile, what is the address, some exceptions here, where is the work being generated, if is the money, for example, having property abroad, you live there, etc. So you need to, one thing here, you need to have the permits, the residencia permits, which is TIE, non-lucrative visa, golden visa. And as the golden visa, you're not obliged to stay X amount of time. It exactly happens with the non-lucrative visa. You could come here, have the intention to stay more than 6 months, but you don't reach the 6 months. And even for those who are more than 6 months, they need to use a dual taxation treaty. And for those who've got the TIE, Pedro, obviously, I would say most of the TIE holders obviously are tax resident in Spain, but there is some exceptions here which you'll need to look into it, the two laws, the Spanish law on tax and the UK, and that's the dual taxation treaty from 1977. So there is a possibility, but all these questions needs specific tax advice and sitting down with a proper and specific scenario. I could not generalize here, but obviously, Pedro, being logical, if you get your residencia, which is your TIE, obviously you have the intention to stay here for more than 6 months, and therefore you need to connect yourself. The second step you need to do is connect yourself into the tax system. So first you will do here when you come to Spain, get your padrón. That's the first residencia administrative paper that you have. It's one type of residency from one local authority, which is a town hall. Second, you've got the immigration side. You're living here more than 3 months in Spain, you're entitled to get that TIE, and you are entitled to give it back whenever you think you're not staying in Spain anymore. Okay, and then 3, Pedro, after 6 months, because with tax office in Spain will not allow you to connect into the system unless you've been living in Spain for more than 6 months and they always ask for your residencia. So the residencia date plus 6 months living in Spain, they will put you into the system. Okay, so basically, Pedro, the answer to your question will be there is a dual taxation treaty, which even though are exceptions, being resident in one country, but paying some taxes in a different one. But you need to always ask for specific advice and tax planning on that specific situation, Pedro. Over to you.
Okay, thank you, Ignacio. Okay, let's go a little bit more rapid and on the PowerPoint. So I would like to answer all these questions. I'm not sure if we are run out of time. Okay, well, about Ignacio, about the healthcare for UK nationals living in Spain. I mean, as I think you have already said about how to access. I mean, if you are an employee, self-employment, or you just pay directly to the Social Security with the Convenio Especial, as we said, there is a limit of whenever you are over 65 or less than 65 years, or if you are registered in the UK with the S1 form with this European health insurance at this time, or living in Spain for 5 years. Obviously, I don't want to stop here a lot, but there is a situation with the Convenio Especial, Ignacio, that we've been discussing that before. I mean, it's an important document that whenever you are inscribed in the padrón for more than 1 year is the one where you have access to that. Is that right?
Correct. As I said, Pedro, sometimes he's catch-22 to get the TIE, because the TIE, we're very happy that we managed to help elderly people who were rejected on the health insurance. And I'm sure that a lot of people, not only on the TIE, have problems with the health insurance company, rejecting to insure you. But going, Pedro, through the non-lucrative visa or golden visa, it could happen exactly the same, right? But one of the requirements to get the public health is for you to be registered in the padron for more than 1 year. That's the only requirement. Then second, you could connect yourself into the system, paying a flat fee of 65 euros, I believe, if you're below 65. And over 65 years old, I think you'll pay 160 something, Pedro, from my top of my head. So for those who are struggling and having problems to register with their TIE because of that, there is a way forward, as Pedro stated, el convenio especial. And I mean, obviously the process is not straightforward because you're dealing with two administrations. On one side, you're dealing with Heredia. On the other side, you're talking to Social Security. And combining things like this is not easy and takes time. But obviously, that will be my recommendation, Pedro, as you said, on the health situation.
Okay, let's go. Let's move on. Just an update about driving license for those who, I mean, before some weeks ago, I would say that you don't have residency on 2020 or before 31st of December 2020, you will not be able to change it or your driving license to the Spanish one. Now it has been extended. If you have you obtain a TIE under the withdrawal agreement, under the Article 18.4 and with Article 50, the Tratado de Unión Europea, TUE, then you will be able to obtain and change the driver license even though you obtain a TIE after. Also, in case that you don't even have a TIE, and if you show the padron, this is why we said the padron is really an important document in order to prove on applications and also in the courts. It's a really important document on immigration on these kind of circumstances. Also, if you have a padron from last year and you are able to show that you've been living more than 180 days in Spain, according to the Act of Transport and Driving, yeah, then you will be able to also to apply and change the driving license. It's been extended also to 31st of December of this year. And for those who already applied or have some verification and application that was made last year and for some reason couldn't do it. So it's been extended and being flexible on these circumstances with the driver license, which is a big issue. Ignacio, is because if I put in the skin of someone who do not have knowledge of Spanish, and in order to make a new test again, it's a mess, I would say. And so we highly recommend to everyone to do it as soon as possible and to give proof of that and change the driver license. We've been doing it, saying that in the last, I would say, the last year or the last 2 years, but okay. Okay, and well, other issues, Ignacio, obviously we are receiving questions about wills. If the Brexit has an impact on wills, on inheritance, pensions, litigations, well, on wills, we always recommend to make a will whenever you have some interest or investments in Spain. You can make a will in the Spanish territory or the worldwide territory. And obviously, if you are resident in Spain, you are resident in Costa Blanca, in the province of Alicante, obviously it will affect you Spanish law unless you make a will and you say you want to be applied into your inheritance, the UK law. You, from British citizens, have the opportunity to choose national law, UK law, or remain in the Spanish law whenever they are residents in Spain. So it is an important act, European Union Act, that attracts you whenever you are resident. And Ignacio, we always recommend to make a will, is that right?
Correct, Pedro. And let me just bring here important point. A lot of people, obviously, we always think it's never a good time to make a will because we're not planning to go, Pedro. But as I said, if you are resident in Spain, and this doesn't have anything to do with Brexit, because this didn't change at all, as Pedro stated. If you're living in Spain, you're resident in Spain, and you never made a will, okay, then the Spanish law will be applicable to the probate. And that's very important, because using the Spanish law in some scenario will not be exactly what you wish. For example, you will leave everything to your wife would like to leave everything to his husband, and then that's not possible according to the Spanish law. There is limitations on children, and 2/3 must go to children. So if you're living in Spain, you're resident in Spain, which obviously with the TIE you prove that you're being resident, then, and you never made a will, then the applicable law for anybody, any expat here in Spain, any other nationality, because only that law is applicable because Spain did sign the treaty, that Reglamento 650/2012, and it's Spain's decision that only applies that law for residents. So if you're resident in Spain and you made no will, then the Spanish law will apply, which probably I do not recommend you, because you might have more free disposal of assets around the world, and you could leave everything to whoever you wish, to your wife, to your husband, to charity, etc., etc. So you have much more control, and it's important to make a will and mention that you want to use your personal law. Okay, very important. Now, for those who you did a will, I will highly recommend you to review whether the will is updated. Okay. And the third thing I might recommend, Pedro, for those who are resident, always do the will and do tax planning, because it's important at the moment, the allowance. I don't know whether you're going to talk about the allowance, Pedro, later on the inheritance tax and etc.
Well, and inheritance, yeah, but we are not going to be focused on inheritance tax really. If you want to do something, but that has not really changed really.
Okay, I will just mention.
Let's make a brief, yeah.
Yeah, I will just mention for those who are resident in Spain, Brexit did not affect that, because of Spanish tax law, and whoever is in Costa Blanca, they will have 100,000 euros allowance per heir, per beneficiary. That means wife and children, husband and children. Okay, and then after that, you don't have so much allowances. And then on main property, you'll have 156,000 euros, 95% of the tax off, if you are a husband, your wife, or children. Okay, that didn't change. And after that, there is a sliding scale. You will pay whatever tax you need to pay, and a deduction of 50% off. Okay, that didn't change, but it's important while somebody is reviewing a will and somebody is doing tax planning to bear these things in mind.
Exactly.
Again, yeah, over to you, Pedro.
It's important to make a estate planning on the wills, on the what kind of taxes you will be able to pay in Spain. It's important to planify. Okay, Ignacio, let's move on to the questions. Well, I think we have run out of time, but let's try to answer them as much as possible. I think you have already answered from Graham, so thank you, Graham, for the question. There are some other questions regarding restrictions because I understand because of the pandemic situation, and but there is a question that says, how do I apply for a TIE under the withdrawal agreement? We have a white NIE. Well, NI number is a tax number. It's not a residence number. It's just a tax number whenever you bought a property, or maybe you bought a different thing, but it was applied for the NI number. I understand, Ignacio, that obviously it will have to show a proof what we already have said about proof of living in Spain and residency in Spain and certification of padrón in Spain, and with that being able to apply for that. Right now it's late, I would say, but it's
Pedro, can you repeat the question from the audience?
How do I apply for a TIE under the withdrawal agreement?
Okay, well, basically,
they have a NI number, just a NI number. I mean, it looks like It's like someone probably they are residents in Spain, but they just have a NI number. They have nothing else about that.
Yeah. I mean, I'm pretty sure then the answer will be, if you were not registered in the padrón, it's going to be a hard case. But if you're able to prove, according to law, that you've been resident in Spain for 2020, only with an NI number, obviously my recommendation will be to do the application. It's going to be rejected, but you will need to go through the courts. And in the courtroom, we'll be able to provide all the evidence saying, okay, I don't have the padron, I don't have these things, but here is the proof, evidence, water bills, electric bills, utility bills, bank statements. I have the €9,000 minimum during 3 months. I have the health insurance or convenio especial, right? And then I will encourage you to apply as long as you comply with the requirements according to law, not just Extranjería, because Extranjería is square with their own formula, and sometimes if you don't have the padron, they will not accept it, okay? But again, there was another question, Pedro, about convenio especial. The convenio especial should be applied through the social security system.
Yeah.
Okay. Obviously, you need the padron. After 1 year, you make the application to be entitled of that and to organize direct debit to pay on a monthly regime to the social security. That's what you could do. I don't think Centro de Salud will do that dealings on social security. You could give a try. Okay, that was a question from the panel here. I think it was Christina.
Okay, let's move on. There are many questions. I'm not sure if we will have time to answer all of them. Okay, let's go to the following question, which is Kristen. So you can use the S1 form as proof of healthcare for the non-lucrative visa. Well, for the non-lucrative visa, you're able to show access to public health or private insurance. So if the S1 form, as we said, it gives you access to the health system, in the Spanish health system, public system, that would be right, okay? So at the end, you need to show that you have a right in order to acquire the public system or with a private system, that it covers you all the same situations as if you were in the public system, which includes hospitalizations and without copayment, okay? Well, thank you, Kristen, for the question. Graham, if you have a TIE and don't spend 6 months in Spain, is the TIE automatically and immediately invalid? Thank you, Graham, for the question.
Okay, thank you, Graham. What you'll have to do is to hand it in to the police station, okay? Other option you might have is grant power of attorney to somebody to give it back. But normally what we've done in the past is to our clients with power of attorney handing over. So the act will be handing over the TIE because you're living, and then informing the tax authority that you will no longer be a tax resident. That will be the proper exercise, Graham.
Okay, I think it's perfectly answered. Let's go to the following question about the TIE. Sarah, how can someone have a TIE and not pay taxes in Spain? Surely they will lose their rights to residency if in Spain less than 6 months per year.
That's been answered already, Pedro.
Yeah.
Obviously, yes, they could lose their rights, but it depends on the type of residency. It's not the same that TIE, then a non-lucrative visa, then a golden visa. Okay, so you need a specific here advice.
Okay, let's go for another question. I mean, I now have a TIE and intend to move to Spain permanently, either later this year or next year, but for work reasons, I am not resident as I'm still living in Switzerland. I gather there is a dual taxation treaty to cover this. We're not sure if you are a citizen from UK. Well, it says Switzerland. Thank you, Stuart, for the question. Obviously, one of the things that needs to be done, Ignacio, is about the tax planning, or whether it's going to be moving at the beginning of the year or the end of the year, first semester or second semester of a year. If that year you are tax resident or not, if you are going to withdraw some savings, some mature, some pension, or if you're going to sell a property that year, that's important to planify. Is that right, Ignacio?
Correct. That's exactly right, Pedro. Doing tax planning is key now, especially because of Brexit. You know, it's been always a good exercise for everyone, but now, even with all these changes, we highly recommend you. And it's not complex. You could just organize even video conference through the person who you need to speak to, on a private consultation and do a tax planning simulation. And I'm sure that you'll be happy because a lot of people has a relief on having the information. And unfortunately, Pedro, the information is very specific to every individual. It's not the same for one than the other because it's different circumstances. So I encourage them to join.
But Ignacio, it's important to also to say, when you have already said about the double taxation treaties in order to avoid double taxation, and obviously as Stuart has been saying about these dual taxation treaties, Spain has a double taxation treaty with, I would say, all European countries and many in the world, in order to avoid it to pay double in some situations. So there are some ways that you have to pay in Spain, there are some ways that you have to pay in your home country, and there are some ways in order to pay in home country and then deduct it in Spain, or vice versa. So it's important to identify perfectly where the income comes. If you are subject to pay or declare taxes in Spain, for example, if it's a government pension, and in order to identify perfectly what is income and also what is not income, if it comes from a life annuity, or if it comes from a pension, or if it comes from savings. I mean, this needs to be perfectly identified in order to show it perfectly in the tax declaration in Spain, according to the double taxation treaties. Okay, I think, Ignacio, I think we are out of time, really, and I think we are close here. If you could include your email, please. If someone would like to make questions to us, I will include it also in the chat. Okay. And Esther, I would like to give you the last word. Te paso la palabra. Hemos terminado ahora mismo. Y nada, muchísimas gracias. Thank you very much.
We have finished. Thank you very much.
Very, very good. We would like to speak about a lot more and be a little bit more accurate and obviously to answer all the questions, but obviously we are running out of time. So gracias, Esther, por el tiempo dedicado y porque, bueno, por la
Thank you for the time, Esther, and for the opportunity of giving information and informing all the participants through this webinar. Thank you very much, especially to you both, because you have been with us this morning, you have accepted our invitation, and you are experts with lots of experience in this subject, so it is quite useful for us. It is a privilege for us. Thank you very much for your presentations, for all the information that you have provided with in 1 hour, which is a lot.
A mí solo me queda de alguna manera también dar las gracias a todos.
I would also like to thank all the participants. It is true, and we are aware of the fact that we cannot reply all the questions, that every specific case is different, and it is difficult to make generic replies to all of you. The situations are multiplied because not one single case is exactly the same to another one. So it is impossible to reply to all of them, and some of the questions they may not have an answer now, but we still have our communication channels which are open through our web, ciudadanosextranjeros.es, and through our email, and also in the website that is going to be operational the full year, Brexit, Diputación de Alicante.com. You will have all the updates on Brexit. It's going to be updated every 15 days. We are going to answer the questions that may have not been answered during this webinar due to the lack of time, and also those people that have access to the webinars late or couldn't see any of the webinars, you will have the links to the YouTube webinars, both in English and in Spanish, on this website. So any person that may have a question that has not been sorted and couldn't have access to the webinars, to the 3 webinars, because we have been talking to residents, to permits, to driving licenses, etc. So you can go back to the website and go to the links of the webinars and check the information that we have uploaded. Maybe your questions are going to be answered with that visit. This is our last webinar, but we will be operational all the time at the service of the citizens and obviously the British citizens living here. I imagine that this is not going to be the last contact that we will have, because as you know, we have a limited time today and you have to give lots of information, so it's not possible to convey all the information. So I wish we could extend the information that you have provided with today and to close this subject for the legal aspects. You have given your email, so thank you for that. And that would be great for future doubts. There are many municipalities where we have Pangea agencies or services for customer services. And those are several points where you can have access. Even if you don't reside in the municipality where you go, you can go to those agencies, Pangea agencies or customer service points, and you will have customized attention over there, customized assistance. So we have several ways of helping that are open to support these nationals, these British nationals in this critic year after Brexit, and to help them sort out the problems they may have with the Brexit. Thank you very much, Ignacio. Thank you very much, Pedro. And we are open to keep on communicating to you all. So if you have any questions, any doubts, please communicate them to us. So we've run out of time, I guess. So thank you very much. And I say now bye-bye to you all. Thank you.